Could you describe the method by which Mr. Smith donated his DNA sample?
It was in the form of a semen sample, Your Honor.
Is it usual to request that DNA be supplied in this manner in criminal cases?
An opportunity arose to retrieve a DNA sample of the accused in this manner, Your Honor.
Could you be a little less elliptical in your description of the way in which the sample was obtained?
The accused had an ejaculation, Your Honor.
The accused was asked to ejaculate by the arresting officers?
That is negative, Your Honor. The DNA sample was recovered after the accused voluntarily, what's the word I'm looking for? Disinvested himself of the sample.
Objection. My client produced the DNA sample in a non-voluntary fashion. It was a non-voluntary disinvestment.
Now this, counsel for the defense, is in a nutshell your entire contention. Am I correct?
Objection!
Please, let the counsel for the defense give some form of explanation.
Thank you, Your Honor. My client was kept in cells on the nights of the 24th and the 25th, where he had neither the privacy nor the materials to masturbate, as he regularly does. After 2 consecutive days in custody, my client became so pent up, in the medical sense, that it caused a non-voluntary nocturnal emission, which was then recovered in part from the cell surfaces by duty officers trained in forensic recovery. But I must stress this. The nocturnal emission of semen collected from my client was non-voluntary, and the collection as such violated my client's rights under the 4th and the 5th Amendments, and in any case should be viewed as an evidence non-admissible in court, Your Honor.
He ejaculated voluntarily!
So what you're saying is, the accused did something to himself to cause the ejaculation of the semen, which became the DNA sample?
That is correct, Your Honor. And whether this ejaculation occurred through his own physical manipulation or some sort of frottage, I think I'm right in using that terminology. The fact remains that this was an act completely auto-voluntatis, leaving DNA samples in quantities on the surface, furthermore on the surface of precinct property. And therefore there was no abrogation of accused rights in this collection of semen. DNA sample, Your Honor.
Your Honor, the prosecution can offer absolutely no evidence that my client made an ejaculation of semen that was voluntary in any way, form, or manner. I'm not disputing the fact that my client ejaculated in the prison cell, Your Honor, but I will vehemently assert that it was non-voluntary.
Your Honor, with all due respect, counsel for the defense has both in pre-trial depositions and today in argument stated that the accused is a masturbator.
That is absolutely not the truth, Your Honor. I have stated that my client regularly masturbates, but that is, to my mind, absolutely a different thing from being a masturbator. In fact, it is precisely because my client was denied his regular access to this entirely healthy form of tension release for such a protracted amount of time that offers the most incontrovertible proof that the ejaculation of semen that my client made in the cells was emphatically, and I cannot emphasize that enough, non-voluntary.